Hello, this is Law and Terrorism, the podcast series. I'm your professor, Glenn Torres-Spelliscy. Thanks for joining me. Thanks for joining me for this week's edition of 5 Key Questions. The topic this week relates to how the core international human rights have been affected by the war on terror. So let's get started. These are rights that have been universally accepted and are arguably principles of use cogents. If you remember, that term means that they represent the most fundamental principles of our international system. The first core right would arguably be the right to life. It is universally recognized and accepted right that can only be violated by states in limited instances. Other rights that fall into those categories would include the prohibition against torture, and although the right to liberty can be curtailed in certain instances, there are certain due process rights, including the right to a trial before an independent tribunal, the presumption of innocence, and the right to know the charges against you, that are accepted as principles of use cogents. The right to life protects individuals against the arbitrary deprivation of life. The key word there is arbitrary. Arbitrary means without a legitimate reason, an autocratic and unrestrained use of authority. The killing of a legitimate military target is not arbitrary, nor is the execution of an individual sentenced to death pursuant to legal process. The use of lethal force in other circumstances, however, is severely curtailed under international and domestic laws. The European Human Rights Court has, for example, held that if lethal force is used in pursuing an alleged terrorist, when there were other means that would not have caused the loss of life, then the use of force will be deemed unnecessary and illegal. Some questions about this arose with respect to the U.S. operation that killed al-Qaeda leader Osama bin Laden. UN officials questioned whether the planning of the operation allowed for the possibility of capture. It is important to note here that the UN views the conflict with terrorism as a criminal matter, and as such, they believe the law enforcement model applies. That view, as we've discussed, is not shared by the U.S. administrations. Nonetheless, the White House did state that the possibility of capture was provided for, but that bin Laden resisted, and therefore his killing was justified.
Thank you, sir. I wanted to ask about the specific goal of the raid. Was there a consideration to trying to take bin Laden alive, or was the mission to kill him on sight?
Absolutely, it was to prepare for all contingencies. If we had the opportunity to take bin Laden alive, if he didn't present any threat, the individuals involved were able and prepared to do that. We had discussed that extensively in a number of meetings in the White House and with the President. The concern was that bin Laden would oppose any type of capture operation. Indeed, he did. It was a firefight. He therefore was killed in that firefight, and that's when the remains were removed. But we certainly were planning for the possibility, which we thought was going to be remote, given that he would likely resist arrest, but that we would be able to capture him.
The prohibition against torture, cruel, and inhuman and degrading treatment is not only codified by numerous conventions, it has without question reached the status of a principle of use cogents. This means that no derogation from the prohibition is ever permitted. The Human Rights Committee's comment number 20 emphasized that there can be no excuses that would permit the use of torture, including the fight against terrorism. The comment provides that, quote, no justification or extenuating circumstances may be invoked to excuse a violation, close quote. The conduct of the person subject to the prohibited treatment, even a terrorist, and even the purpose of the treatment, i.e. to exact information, is irrelevant, as are the potential benefits that could be gained as a result of the treatment. Under IHRL, even in a ticking time bomb scenario, torture would not be permitted. Well, international law does protect certain due process rights, including the right to a trial before an independent tribunal, the right to be presumed innocent, the right to know the charges against you, and the right to counsel. However, in situations where national security concerns are present, the law provides some additional flexibility for state parties with respect to detention practices. A state in a national emergency can typically detain someone for longer than normally would be allowed under human rights law, provided certain procedural safeguards are met, including an impartial review of the circumstances of detention. It is important to recognize that the right to liberty is not a non-derogable norm of jus cogens. That means that in certain situations, particularly in times of national emergency, a state may be able to justify prescribing an individual's right to liberty. The political rights relating to expression, association, and assembly typically fall within the category of rights that can be derogated from in times of national emergency, provided such derogations meet the criteria of necessity, proportionality, and legality. Further, while international law recognizes the primacy of free speech and association rights in democratic societies, it also recognizes that states should be able to place limits on that speech if it incites violence. Well, that does it for this week's introductory podcast. Let me know if you have any questions, and I will see you next week for a new installment of 5 Key Questions.